Good afternoon to everyone at today's public hearing of the Vetting Commission established under Law 65 of 2023 of the External Evaluation of Judges. I am Andrei Bivol, Chair of Panel A of the Commission, and declare this session open. This hearing is being conducted under Law 252 on the External Evaluation of Judges and Prosecutors and under the Commission's Rules of Organization and Functioning as part of the evaluation process. The subject of today's hearing is Grigore Dașchevici, judge at the Central Court of Appeal, previously Chișinău Court of Appeal. George Dașchevici, welcome. Good afternoon. I'm joined at this hearing by the other two members of the panel. On my left, there's lovely Perling, international member of the Commission, and on my right, national member of the Commission, Lilian Enge. The panel is also assisted by members of the Secretariat who are in the room behind you. They are representatives of the media and the public. Also, there's a photographer that will take a few photographs at the beginning of this hearing. The hearing will be conducted with interpretation between Romanian and English. To allow for accurate interpretation, I ask everyone to speak clearly and slowly. Moreover, the recordings are recorded. The recordings are usually published within 3 days on the Commission's website. If part of the hearing is closed, that part of the hearing is not published, but it is recorded and included in the evaluation file materials. During the hearing, one or more members of the panel may ask you questions, and I ask you to answer truthfully and completely and to the point. Your explanations are important to the panel in verifying your financial and ethical integrity. At the end of the hearing, you will be given an opportunity to make a brief closing statement. In posing questions, we will consider your privacy and, if possible, we will avoid mentioning details such as cadastral numbers, exact addresses, bank account numbers, and even the full names of certain persons. And we ask you to do the same. I will now mention briefly the evaluation process for Judge Dașchevici. The Commission initiated the evaluation on 11th April 2024 by notifying Judge Dașchevici by email and asking him to complete and return an ethics questionnaire and the declarations required under Law 252. Mr. Dașchevici returned the completed declarations and questionnaire on the 30th of April 2024. As part of the evaluation of a subject ethical and financial integrity, the Commission also obtains information from many other sources such as the National Integrity Authority, the State Tax Service, the General Inspectorate of Border Police, other public institutions, financial institutions, and open sources. The Commission assesses the information it obtains for its relevance and reliability. Between the 13th of September 2024 and 13th of January 2025, the Commission asked Mr. Dașchevici to answer 3 rounds of questions and received answers for all rounds of questions. On the 31st of January 2025, Mr. Dașchevici was informed in relation to the areas of doubts identified that will be discussed in relation to his compliance with the ethical and financial criteria. You were also invited to today's hearing. Mr. Dașchevici, would you like to make any corrections or additions to the answers that you provided previously? I would like to mention only self-declaration from my wife and also the self-declarations from 2 persons. This is related to the additional expenditures CP. Thank you. You can offer them to the Secretariat after the hearing, and you can refer to them during the hearing if needed. Mr. Dașchevici, the answers that you offered to the Commission in the ethics questionnaires and the declarations that you returned on the 30th of April 2024 are still accurate as of today? Yes, they are accurate today. Thank you. Now the members of the panel will ask you questions on the doubts that you were notified about, and Madam Perling will start.
Thank you. Good afternoon, Mr. Dașchevici. We would like to clarify some aspects, and during the interview, I would like to ask from you questions about the 7 issues, about the apartments, cars, saving and donations, generally inexplicable wealth, the acquisition of a commercial space, conflict of interest, and your participation in, let's say, ECHR cases. And I ask the questions, or I take the topics in chronological order. So let's start with a topic about apartment in Kalarasi city. You know what I talk about, yeah?
Da, sigur că.
Thank you.
Yes, of course.
So, according to your written clarification, you and your family, you lived in this department for 20 years, between 2023 and 2023. And just that to provide a bit of context, I describe you facts, and you think, do you confirm? You have acquired this apartment in 2003, when you have sold it to a third party in 2010, but you continued living in the apartment. According to the official data, in 2012, your mother-in-law reacquired this apartment from the third party. And in 2021, she donated this apartment to your wife. Is it correct?
Este corect.
Yes, it is.
And now my very simple question, please tell us very shortly, what is or what was the point of buying, selling, reacquiring by your mother-in-law of this department?
Deci după
As mentioned in the rounds of questions, I've explained that in 2010, my family...
Thank you. Thank you for all your answers. I know you answered. Just I asked, what was the point if you clarify it so shortly as it's possible? I just tell you that it's not necessary to repeat your answers. We have read all the answers. Just very shortly in your own words, what was the idea of all the deals during the 20 years?
Deci
When the apartment was sold in 2010, the purpose of the sale was to get some money from it and buy an apartment that is larger.
And very shortly, why you didn't buy the apartment, new apartment?
As mentioned previously, do you mean why I didn't buy it back? I didn't understand the question.
First question, why you didn't buy the new apartment? Okay. My first question, why you didn't new buy apartment? Yeah.
fiindcă vânzătorul
Because the seller of the apartment that we intended to buy decided not to sell it.
Thank you. And as your mother-in-law acquired this apartment, then my question is, why you didn't acquire this apartment where you lived?
How should I explain? So I was actually looking for another apartment. We wanted to have another apartment to move from 2 rooms to 3 rooms. But time passed by, And I'm sorry. Now I remember what happened. So we were actually looking for this apartment that I was discussing about, but given the fact that we had an agreement with the buyer to live in it after the sale, I knew I had time to find that three-room apartment. If not the one that I mentioned, then another one. So time went by. This period that we had in the contract, that we had at our disposal to move out of the apartment. And after this period, we had an agreement with the buyer so that we could still use this apartment until the end of the year, until December. And during this period, my mother-in-law stepped in. I don't want to get into details. I explained thoroughly. So it's about her daughter. She was somehow worried because she didn't really trust me. And this is why this apartment was purchased by my mother-in-law in 2012, if I'm not mistaken.
But then in 2012, when your mother-in-law bought the apartment back, what about you? Did you have had money yourself buying back this apartment?
Da, banii erau
Yes, we had enough money to purchase this apartment. I don't know why, but I was still focusing on changing the apartment, personally.
Okay, thank you. As I understand, you just didn't want to buy a new apartment. Or you tried to find, but you couldn't find it.
Nu. După ce a fost
After the apartment was purchased by my mother-in-law, I don't know how this happened, but the issue disappeared naturally. And in 2013, there was this project related to preferential price apartments. And at that point, I told my wife that it would be good to invest the money in the apartment in Chișinău from Romana Street.
Thank you. Now let's continue exactly with the other apartment. I describe your facts, you confirm, agree or disagree, please. On 16th of September 2013, like you said, you submitted your request to be included in the list of beneficiaries of apartments sold at the preferential price by Paskolunsk LLC, yeah? And this request culminated with your acquiring 71.1 quadmeters apartment near the center of Chișinău. Is it correct?
Exact.
Thank you. And you
Exactly.
mentioned in the request that you have registered residency in Chișinău municipality but didn't have living space at your workplace, Kalarasi city, or in Chișinău. Is it correct?
Can you repeat this, please?
You mentioned in this request
Da.
that you have registered residency in Chișinău municipality but didn't have living space at your workplace, Kalarasi city, or in Chișinău.
Exact.
Exactly. Thank you very much. And you had registered residence in Chișinău because 3 days before submitting the request on 13th of September 2013, you changed your address from Kalarasi apartment to an apartment in Chișinău. Is it correct?
Nu țin minte.
I don't remember the timeline and the exact data when I changed my residence, exactly the date.
But now, just for a moment, back to previous apartment. As we understand that also at the date of this request, you didn't have a living space at your workplace because you have sold your Kalarasi apartment in 2010. And then it was acquired by your mother-in-law. So on paper, you didn't own any living space at the date, but really you did. Is it correct?
O întrebare interesantă.
The question is interesting. Yes, I had a place to live, but I didn't own an apartment. That would be the answer. Yes, I was living in the apartment of my mother-in-law.
But at that time, the apartment belonged to your mother-in-law.
Da.
And she made
Yes.
it as a donation to her daughter. Is it correct?
În 2020.
In 2021, if I'm not mistaken.
And for understand that acquired an apartment through the program, what we talk about, the program, that was designed for those who didn't have a residence in this area. Is it correct?
Lipsa spațiului locativ.
Yes, the main criterion was the lack of living space. No, there was one exception. The person could have benefited from this reduced price if they had an apartment that was smaller than they should have had. So if there are more children in the family, let's say, if I remember that those were the conditions. So it was not mandatory to not own an apartment, but it was also for improving living conditions for some families. For example, families that had several children.
And last question about the apartment. What about the price of Kalarasi apartment price? When you bought, when you sold, and when you required? Were there some kind of loss to new owner or?
Nu aș spune că a fost o pierdere.
I wouldn't say it was a loss for anyone. So that you understand, the city of Kalarasi is more like a village. Administratively, it is a city, but it is basically a village. And the prices there were never high. Chișinău is the only city where the prices were different from the other district centers. And even currently, I can say that approximately the prices are 50-60% lower than in Chișinău.
Thank you. Maybe my colleagues have questions about the apartments, or I continue with the cars. Okay, thank you. Let's talk about cars, Mercedes. And again, first of all, the facts. According to official data, you had use rights over Mercedes E220. And it was between September 2010 and August 2013. And in your written answers, you mentioned that you registered use right over this car after it was acquired by your younger brother from your brother-in-law. And you also mentioned that your brother didn't manage to register ownership over this car because he had to leave the country. And my simple question is here, who mostly used the car? Now we talk about Mercedes from 1999.
Nu putem spune cine a folosit.
I cannot say who used the most the car. I declared the use of that vehicle, and I want to say that I use this car occasionally. I want the Commission to understand what would be the meaning of me using that car. The apartment I was staying in was at 300 meters from the court. The idea is that I needed no vehicle to travel to work.
Yes. But you said that you cannot say who mostly used the car. Of course you can, because it belonged to your brother and your brother was on abroad. So still my question, just the fact, please try to answer. Who mostly used the car?
As you worded the question, it results that I would be the one to use the car mostly in time.
Thank you.
If we talk about 1 year, calendar year, yes, for example, let's say if my brother would come twice a year or once a year for 2-3 weeks, yes, the idea would be that I would be the one using the most the car in time.
And next question, who was the real beneficiary of the car?
Beneficiarul fictiv al automobilului.
The real beneficial owner of the car was my younger brother, Igor.
How? Could you explain?
La ce vă referiți?
What do you mean?
You are a lawyer. If I ask about real beneficiary, who was the real beneficiary?
Am înțeles. Dacă este...
I understood your question. The question is that the vehicle was registered in my brother-in-law's name. Yes? Is that the question? But I want to tell you that in that period, very often actually, people used to buy the cars without registering them with the competent authorities. Meaning, let's say that we issue a general power of attorney. That was what it was called like, with all the rights of proper use and sale. And for this car, the beneficial owner of that car was my younger brother, Igor, because he declared this.
As I understand, but let's now talk about the next Mercedes. And this Mercedes we now talk about, this is from the year 2004. And according to official data, after the previous car, you had use rights over another car and of the same model, Mercedes E220. And it was between July 2013 to July 2018. And as the previous car, this Mercedes was also registered on your younger brother between between the time. And I have the same question. Who mostly used the car?
The same answer. If we talk about the time, the period when my brother was in the country and myself, it results that I was the one to use the most the car than him, because he either was abroad and came just from time to time in the country.
But let's talk about a little bit the money what was used to buy this car. According to your wealth declaration, this car was acquired by your brother in 2013 for 128,000 lei, which is about 7,655 euros. The income of your brother was in this year, 2013, 11,486 euros. So that means that about 66% of income he invested to this car. Do you confirm it?
You want me to confirm what? The percentage from that income? Or
Okay, you can say. Do you know what was the income of your brother? Do you confirm it was 11,486 euros in a year?
Nu am datele.
I don't have the data in front now.
Approximately, yeah.
Cred că așa.
Yeah.
I believe so.
Yeah, and that's the fact that this is 66% of his income. And I ask the question: do you confirm that, or maybe I should ask, do you believe that he invested 66% of a income to a car?
Deci, la această întrebare,
In relation to this question, I want to explain that, as a rule, a vehicle is not bought from the money you acquire during 1 year. Usually people save. Regarding my younger brother, he works abroad. He's been working abroad starting from 1999 in Portugal. Later on, in 2007, if I'm right, he moved to Spain. Therefore, I cannot state or confirm that he bought that car from the money he acquired in 2013.
Okay, what is your opinion? Why your brother needed the ownership of a car? Why you didn't acquire this car and didn't just give the car to use for your brother?
explic.
I explain. Initially, my brothers were very close to the country, felt this close connection to the country. They had the idea to come back to the country. But as you may know, time passes by. People understand that they have lower opportunities in Moldova, and that they decide to stay there where they work.
You talked about your younger brother. Do you now have some kind of data about his income, because you have not provided it us before?
I did present the data to the commission about his income and the older brother too.
Okay, we can clarify it later. But do you confirm the fact that after 2018, when your younger brother sold the Mercedes from 2004, and you acquired Volvo car, which you have owned until 2023, your brother didn't own any other cars in Republic of Moldova?
Fratele meu n-a avut nici...
You mean my brother?
Yes.
Sorry, but I didn't understand the question actually.
Dacă ar fi avut
Ben
un alt
he's all-
automobil în Republica Moldova?
Did he have or not a car in Moldova?
When, after the 2018, when he sold the car, you bought your own Volvo and you didn't use any more the car of...
Okay.
yeah, that means that he didn't need any more car in Moldova.
Păi, eu am spus deja,
I already said if we go back in time, I already said that at a specific period in time they understood they had nothing to do here anymore. They could not develop by their activity. They were better paid there where they stayed abroad. So they kind of stopped the relations or thinking about the country.
Thank you. I don't ask any more question about the cars. Do you have questions about the car, Lilian?
Could you tell us, please? Let's go back to those two cars, Mercedes. So the older Mercedes was in your ownership by till 2013. You mean owned? I was using it. Yes. But at the same time, 4 months earlier in March, also 2013, the newer Mercedes car was bought. Do you know how this happened? That the new car is bought whilst the old car was not sold yet. I cannot tell you right now about the reason to buy this new car by my brother. It's hard for me to express myself on that. I did not know what was the reason for him in that moment. I mean, maybe you know, or maybe you remember about the buyer of the old car. Was he the owner of the new car, or maybe that was an exchange, or what were the circumstances, if you know? I cannot tell you because it's been a lot of time already. It is very hard to remember specific circumstances because it's been more than 10 years. Mr. Dașchevici, did you take part in the transaction? Did you participate in the sale of the first Mercedes and the procurement of the second? I'm sorry, but what do you mean by assisting or taking part? The idea is that your brothers were abroad. So the question would be if you were in charge for the sale and purchase of the cars. No, it wasn't me.
Thank you. Let's continue with cash savings declared by you. And first of all, let's talk about cash savings declaring at the beginning of an evaluation period. Okay. Just to give the frames to the questions, you have declared in your written responses that at the beginning of 2012, you had cash savings from very various sources. $5,000 received on marriage event, $1,000 received on christening celebration of your first son, $350 received your wife's birthday, 1,500 euros received from christening celebration of your second son, $1,500 was saving accumulated between 1998 to 12/11, and $600 and 2,000 euros is received at your 14th birthday anniversary. And at the same time, Commission also identified various large expenses that you would have incurred during the same time when the alleged funds were accumulated. For example, acquisition of apartment in Galaraši, what we already talked about, Volkswagen Passat in 2002, Volkswagen Passat in 2006, possible acquisition of a Mercedes and acquisition also of us. So, very shortly, your cash savings and your expenses before evaluation period, what you said, that this is your cash savings. Could you please just explain us shortly how it was possible that you saved until 2012 all the mentioned funds received since 2001, considering all the expenses?
Referitor la
Regarding the vehicles that were registered in my name, the Renault and two Volkswagen vehicles, I repeat that those were registered in my name, but actually those belonged to my older brother because those were bought from his money. It was not an expense incurred by my family. Yes, I understand right now that such things look at least not serious from my side. But that was the case at that moment in time. If my brother asked me, I would not do this. No.
Okay, so confirm your savings, but why I ask that, could you just explain us how it was possible that maybe there were some kind of principle, how many percent from your savings you used every month, because it's difficult to understand, or how you saved all the money all the years, and at the same time you have expenses.
So, once again, those were not expenses coming from my family. If you talk about the 3 cars, this is sincerely from my side. It was not from the budget of my family. But regarding how we saved the money, I can only say that my family was educated to make savings. And if you look at the following years, or all the years, including in the evaluation, you'll see that I always had savings in cash. That's a way of life. It depends on education in your family.
But if we talk about the monetary gifts, you have declared all the monetary gifts received at various events in the period before 2012. But
Yes.
why didn't you declare monetary gift in your wealth declaration submitted for the period of 2012 to 2023? For example, you declared your birthday gifts, but your wife would have had her 14th birthday anniversary in 2017, and you have had your 50th birthday anniversary in 2021, but you have not declared the gifts. Why the difference?
la 50 de ani ai mei nu.
For my 50th birthday, I did not celebrate. We did not have any celebration. We just celebrated at home with my wife and kids.
Okay. Let's continue with donation. And first of all, let's talk about donation 9,000 euros received from your brother Leonid, yeah?
Mai mare.
Yes, you're my older brother.
You mentioned in your written responses that your older brother donated to you 9,000 euros in 2013 for your purpose of making a payment for an apartment in 2014. You didn't declare this income in your 2013 or 2014 wealth declaration. According to information provided by you, your brother received in 2013 an annual income of €8,830 from his work abroad. My first question, could you please explain why you didn't declare this income in your wealth declaration?
As mentioned in the previous rounds of questions, I didn't declare this because Law 1264 was ambiguous. So I discussed with the representatives from the National Integrity Center. And besides that, we, the colleagues, used to discuss among ourselves. And we discussed that this financial support from first-degree relatives, such as brothers, were not subject to declaration. Maybe it was my mistake. But this is what the situation was like back then in 2013.
Sorry, I now lost. Was it your mistake, or you think it wasn't necessary to declare? Because, as I understand, the law has changed. So, is it one or another answer? Is it your mistake, or it wasn't necessary to declare?
It wasn't necessary to declare it.
It wasn't necessary.
It wasn't necessary to declare it.
It wasn't necessary. Could you please tell us? It was. Okay. Okay. Yes, I understand it. And my question is, maybe you know the norm, maybe you have checked now why you think it wasn't necessary. Norm of a law.
I don't know how I could explain now things that happened in 2013. But I didn't consider this as a donation per se. And even about donation, the judges, considered that they didn't have to be declared if they came from first-degree relatives, mother, father, or siblings.
Okay, this is your answer. But let's talk about the money itself. In the context that your older brother, he also have some kind of expenses on living abroad, how it was possible that he donated you a sum which is larger than his 2013 annual income?
You need to take into account the fact that he has savings because he's been working. He was working in Portugal and in Spain and then now in Germany since 1999. And as I explained, it is a habit in our family to save money in cash. This is how we were raised by our parents.
So as I understand, it was his cash savings from previous year.
Exactly.
Okay.
One mention. He wouldn't have given me the last money his family had if he didn't have this money.
But let's now talk about donation from your mother-in-law. In your written responses, you indicated that your mother-in-law had donated to your wife 15,000 lei in 2012, 15,000 lei in 2013, 30,000 lei in 2014 and 35,000 lei in 2015. Is it correct?
Corect.
Thank you.
Correct.
And can you now provide us some kind of more details on how the donations occurred and how the sums were spent? Some kind of big things that you thought that bought or just everyday expenses?
So, as a rule, if we have the family budget, part of it is spent, and what is not spent, we save it. So we put it on the side, as Moldovans say. And you were asking me about how they occurred, these donations, right?
Yes, for example, was it necessary to buy something big and your mother-in-law donated it, or it was just everyday expenses?
My mother-in-law made these donations monthly from her income. This was for her daughter, which was having some financial difficulties at that point, let's say, because she had 2 children and she was on childcare leave. And this was financial support that is still ongoing as of today. Well, maybe not today, not financially, but she's helping with food items, even when we don't really need it.
Okay, that means that every month she gives you some money and you save it. Is it correct? Or spend, yeah, it depends.
Depinde.
Depends. So, my mother-in-law, who is offering this money, well, I am not tracking what happens to this money. Did you spend it, or what did you spend it on? Usually we have the family budget. It's not my money or your money. It's a joint budget. And if needed, we spend from it. If not, we don't.
So, and last question about the donations. You didn't declare the sums between 2012 2015. Why? Wasn't it necessary or in any other reason?
It wasn't necessary to declare these donations from first-degree relatives.
Thank you. No more questions about the donation? Sorry, yeah, continue.
Am vrut să spun, deci
I wanted to mention that we can't really name it donation. It's like financial support from the mother to the daughter. I'm not sure if this would be called a donation.
Thank you. No more questions about donations.
Domnul judecător, dacă nu calificați...
Judge, if you don't qualify this as donations, or how would you name it? What is this support from a legal point of view? I think that we shouldn't interpret the law now. What's a donation? What is financial support? I'm not asking you as a judge, but as a person with a legal background, how would you name this contribution? If possible, I will abstain. You said that you didn't have clear tracking on how this financial support from your mother-in-law was used. And you said it was somehow included in the budget of the family. Maybe I didn't understand this correctly. I want to clarify, was your mother-in-law living with you? Were you in a joint household? No, she was living in a locality that is next to Călăraș city. And this was cash that was given to your wife? Yes, usually this was done monthly. So from her funds obtained from her job, or yes, from her workplace. I understand, thank you.
Okay. Thank you for your answer to our questions about inexplicable wealth. I just ask some general additional questions. First of all, you know that the Commission has identified negative balance in income and of outcome in years 2012, 2013, 2014, 2016, 2017, 2018, 2019, 2023. How do you explain the negative balance of a years?
There is no negative balance. Given the fact that this Mercedes is considered as my property, the one from 2004, then indeed then there would be a negative balance. But as I said, these vehicles belong to my younger brother. So this is why we have this negative balance. Moreover, the Commission questions the savings I had up to 2012. So under these conditions, of course, there would be a negative balance, but indeed there is no negative balance in reality.
Thank you. Let's talk separately about the year 2016. But according to information available to the Commission, in 2016, your household appears to have total outgoing financial flow that exceeded your total incoming financial flows by at least 62,699 leis. And during round 3 questions, when you were presented with 2016 negative balance, you mentioned for the first time that 80,000 leis proceeds from selling the Toyota Corolla in 2015 and were transferred as cash savings in 2016. Just the question, why you didn't declare this sum as cash savings for the end of 2016 during the first round of questions?
This was an omission from my side. The sale of this car, the Toyota Corolla, was the price that was mentioned in the asset declaration.
Okay.
So I omitted this.
Okay, you mentioned the sum and not the car. And now let's talk about year 2023. So according to the information, we see that the misbalance is minus 161,437 leis. And resulting from your responses to round 1 questions and your 2022 and 2023 wealth declarations, you have spent in 2023 minus 430,000 lei on building a house. During round 3 questions, when you were presented with 2023 negative balance, you mentioned that this sum wasn't actually spent in 2023, but in the first 3 months of 2024. before submitting the 2023 wealth declaration at the end of March. And as I understand that you claim that this sum was spent outside of evaluation period. But from the available information, it clearly results that your household has spent 1,050,000 lei in 2022, 430 lei in 2023, and another 450 lei in 2024. And very simple question, why did you change your initial claims in this regard? Why you changed your...
Nu am modificat.
I didn't change anything.
Okay.
În ce sens am modificat? Nu am modificat.
What do you mean by the fact that I changed? I didn't make changes.
Could you, maybe you know in front of you, you could explain us your household spending 2022, 2023, 2024.
Mă scuzați, nu am înțeles întrebarea, adică care era?
I'm sorry, I didn't get the question. You asked.
You have sent us the answers. It's enough.
Deci, doar cu o precizare.
I'd like to make a clarification.
O claritate în această.
So I want to make things clear on this issue. Referring to the declaration for 2023 and the amount that you mentioned, those 430,000,
Pur și simplu, deci ca să fie o claritate, eu vă spun cum
I will tell you
cum au preluat evenimente.
how things happened.
Până la data întocmirii declarației despre
Before the date of filling in the declaration on assets and personal interest,
am întrebat-o pe soția mea
I asked my wife what were the expenditures for the building of the house. She looked in the drafts she had and she declared this amount.
fără să clarific cu ea
And I didn't clarify with her what were the details when this money was paid. So I mentioned in the declaration of assets and personal interests that it was spent in the calendar year 2023. However, in fact, this amount of money was spent between January and March 2024 probably. And I didn't pay attention to this aspect.
veniturile soției mele
And the incomes of my wife allow her, and also allowed her previously,
suma asta de bani.
to cover this amount.
Thank you. And my last question about inexplicable wealth. You explain now that we should exclude the car because the car belonged to your brother and your brother paid by the car. What was the price of the car? What you think we should exclude?
La care automobil vă referiți?
Which car are you mentioning?
Let's talk about the second car.
Mercedes.
Yeah, both are Mercedes.
Sumă. Deci, la primul automobil.
For the first car, I don't know the price. I know the price of the second car because due to and this is the information that I had in the declaration of assets. This is the only reason why I remember the price.
And the price?
Adică
128,000 lei, according to the declaration of assets. This is what my brother declared.
But how you explain that your the misbalance? Okay, let's take out this price, but still the negative balance is minus 742,844 leis. Maybe you have any other explanation, some kind of additional explanations?
Am explicații suplimentare.
I have additional explanations. I once again say the Commission is denying my obligation, my savings, but they really existed. That's the root cause of all the issues and the calculation that is not real. What else can I say about this fact from what I recall? What I wanted to attach to the evaluation file, to the discovery file, those additional expenses additional to the CEP, clothes and footwear, those should be excluded too, because my wife did shop online in retail shops or other outlets in cooperation with different other people. So they would order a package which usually includes several products, clothes or footwear, which after they get to the destination point, they are distributed amongst the people who were part in that order. Later on, they would pay my wife in cash. Why do they do so? Because my wife is registered on specific websites, online shops, online outlets, and she's getting some discounts like permanent client or some offers, special offers. And moreover, the costs are usually lower in some cases when the online shops would apply a discount for a specific price. Let's say that we have the order for amounting to 150 euro, the full amount. And the discount would be 25% for the full basket of items. And in that sense, I would like to request the Commission to attach to the discovery file the declarations of my wife and some people who were part in this so-called procedure of
Thank you.
this common shopping.
Can you or would you like to name also the online stores where your wife is a so good client that she gets significant discounts?
No, I cannot recall right now. Birkins something, Dorothy Birkins, if I understood it correctly. I cannot tell you exactly right now.
Okay. Maybe my colleagues have questions about inexplicable wealth? No. Thank you.
Just one question.
Yeah.
Mr. Dașchevici, let's go back to the savings. Basically, the issue is that you state that at the beginning of 2012 you had savings which were the result of a longer period, 10 years. So this would be related to your style of life, the idea to make savings. But let's go back to the realities in which we live. The donations you received, because mostly are related to family events like Christianism celebration.
Orice eveniment de acest gen
and any and the birthdays, and alongside with the gifts, this would entail also some expenses from the organizer, from the family that organizes this. And most positive result would be that you have a zero balance at the end when the costs do not exceed the amount of the gifts. Yes, we understand that those are gifts for those celebrations, but what were the expenditure that your wife incurred for the those events, to organize those events?
Dacă o luăm așa, deci cronologic, să vorbim de nunta...
To look at this in a chronological order, let's say 2001, the wedding, the marriage, and the wedding, the celebration. I can declare with my full responsibility.
Cel puțin, socrul meu decedat.
And there is my mother-in-law,
Deci care pot spune
life, who can confirm
nunta sau
that
cheltuielile de nuntă,
the expenses for the wedding were incurred by both families of our parents. My parents and my in-laws were involved in this process. I don't know how the weddings are organized today, but previously that was the procedure. The parents were the ones to organize the full celebration. They would pay the entire banquet. And there were the gifts. This was the gift. So you say that you had no costs to incur for your wedding. Yes.
dacă nu punem
If not taking into account the suit that I put on. I didn't want to ask you directly, but this was yes. What about the other events, more recent? For example, your christening celebrations, birthdays. You already were a parent that had to incur the expenses. I cannot recall all the expenses that were made at that moment in time. I cannot tell you the specific amount that was used. We did not have significant expenses. Most of the events were organized in a specific hall, banquet hall or celebration hall, kind of a cafeteria at the winery from Călăraș, where my in-laws worked their entire life.
zero cheltuieli și în rest, dacă e o structură de mâncare, produsele...
It was about beverages and drinks and food products were used to be taken from the parents.
Da, deci nu mai intrăm în detalii.
So, to make sure that we understand your answer, the idea is that the amounts or the difference between the incomes and expenses would relate to those amounts, and this would be the net amount income. I do not say we had no costs at all, but we had minimum expenses. Thank you. I am really sorry, but could we take a small break? Just 1 minute?
Da?
We take 5 minutes?
Reluăm ședința.
Okay.
Let's continue and let's talk about acquisition of commercial construction in Călărași city. Now, in 2020, you were already charged. Is it? Yeah, that's fact. Yeah. Could you please tell us again very shortly, because you have explained, but still, please tell us why did you acquire commercial construction in Călărași?
Deci, spațiul comercial.
So that commercial construction, commercial building in Călăraș was mainly bought to be the office of the law notary firm of my wife. That was the idea.
Notary office commercial space. Yeah.
Da.
Yes.
And no other reasons. Because, for example, in business, to earn money, earn profit, it's absolutely okay. But you confirm that it was just for your wife.
Doar pentru soția mea.
Just for my wife, it was bought.
Dacă vă întrebați sub aspect
Maybe you wonder about this area, the surface, which was quite higher, maybe that goes beyond the limits of a notary office. I want to explain to you that there are not so many offers in that town, in the city. Because in that city we have a central street where everybody wants to settle the offices, businesses, and so on. And when we had that opportunity, we did not discuss about the dimensions. Is it big or is it not big? We asked ourselves whether it was not necessary or not, and we had no other opportunity at that moment.
Okay. First of all, let's talk about the sources, resources what you used to buy the building. There were two main sources. One is the notary income of your wife, and the second source is cash savings resulted from the sale of Romana Street apartment, which you have acquired within the SEM program of apartments sold of a preferential price. Is it correct? Thank you.
Exact.
Yes, you're right.
And sorry, I repeat my question, but and you confirm it was your wife. And why I ask, because I would like to understand how you explain the fact that you have used the fund that resulted from the program and mean to improve the living conditions of the churches to acquire an asset that bring you an income that is twice larger than your church salary.
Nu.
No, it was not the case. When the apartment was sold, the one I benefited for a preferential price was not the idea to use it to buy a commercial space. When we sold the apartment, another idea was at the core of this idea. The location was not a very good one, according to our opinion. The quality, maybe. And we actually wanted to buy another apartment in another place. That was the idea when selling the apartment. At that moment, we did not even think about buying the commercial space.
Okay. Let's continue the process of acquiring. Before you acquired this building from Paasa de Transport Auto 28, this company acquired this building at an auction for the same price as you. It was 2,520,000 lei. And this is also the fact that the acquisition by the Paasa de Transport Auto 28 wasn't finalized. When you have signed a pre-sale purchase contract with a company regarding this building and made the initial payment 1,500,000 lei on 18th of July 2019. Is it correct?
După cum mi-aduc aminte, da, 2019
As I can remember, yes, it was in 2019 in July, I think.
And according to the administrator of this company, it wanted to sell this building right after auction adjudication because he discovered after the fact that the building had various legal problems. You confirm it?
I actually did not understand your question. What do you want to confirm?
Problem.
Dacă vorbim de sechestre, aveți în vedere?
You mean seizures or prohibitions?
Yes.
Yes, there were some he mentioned.
And as I understand, you still decided to buy it with legal problems.
Da, ori
Yes, because the seller, according to the pre-contract, they engaged to eliminate all the measures related to the seizures and limitations applied.
Okay, but could you explain why did this legal problem made the respective company resell the building, but the same problems didn't dissuade you from procuring it? You still want it. There were problems, they decided to buy it, but you decided that you are able to solve all the problem. How?
nu eu am hotărât
It was not me who decided to solve the issues. The problems were on the seller, on the party that was to sell the building. The idea you're suggesting is I wasn't afraid to engage in such a trade. Yes, no, but if we understand how the auctions happen, and sooner or later, all the prohibitions are removed. It's not possible that something is sold for in the auction and they remain with the prohibitions applied for always.
It's now very important that according to the pre-sale purchase contract from 17th July 2019, the company had the obligation to transmit you the ownership free of any legal problems or right of third parties. And the sale purchase contract was signed on 27 April 2020, 1 year about. Is it correct? Yeah?
27
27 April 2020, yes.
So my simple question, did the company manage to solve all the problem?
At the moment when we concluded the transaction as of 27th of April 2020, no interdictions or prohibitions were valid. As I remember, there was no legal issue in that sense.
So that means that all, for example, as you said, that there was some kind of seizure orders, everything was solved.
au fost înlăturate?
Yes, those were removed before the sale procedure. Otherwise, the contract could not have been signed.
Okay. From pre-sale purchase contract to final contract, it took 1 year. Could you tell us, please, as it lasted for almost 1 year, how often you talked with administrator of this company during this period?
Deci să zicem așa, deci noi nu ne-am întranjat.
So we did not bother to call each other. So we decided that when they solved the problems, they would contact us and inform about this. It was not that we had to call each other every day.
Okay, not every day, but how often you contacted with a person? How often you call to each other? How often you met?
Explic încă o dată. Deci,
I'll explain once again. I believe we had two discussions because the first one happened when we discussed some questions. They said they couldn't solve some issues, they need more time. We didn't get into details, but they said they need more time because they needed someone's agreement. And I understood this, and I said, call me when you solve these issues. So I think that we had 2 phone calls.
During 1 year. 2 phone calls.
Da. Da.
And they
Yes.
solved all the legal issues.
Până la urmă, deja...
In the end, as one can say, yes.
Let's talk about how you paid for the company or for the construction. You claim that you made 3 separate payments for the purpose acquisition of a building. Yes, 1,500,000 lei in 18th of July 2019, 520,000 lei 29th of April 2020, and 500,000 lei on 28th of May 2020. And you also mentioned that all the payments were made in cash. Is it correct?
Exact, în numerar au fost făcute.
Okay.
Exactly.
Okay. 2 phone calls during 1 year. And now I ask about the payments, considering that this is large sums of money. And you paid it in cash. Could you please tell us how each of the payments occurred? And who made the payments, who attended in the meetings, when the payments occurred, when did you, where the meetings took place, and so on. Just describe first, second, the third.
I won't be able to tell you about all 3 payments, but I remember that 2 of them happened in the following way. The administrator calls their accounting staff, their accountant, who is at their headquarters, and they say, this person will come for this matter. The money is given, the receipt is issued by the company to confirm the fact that they received this cash, and this is all.
And who participated in the meetings?
Contabilul.
The accountant.
Contabilul întreprinderii.
The accountant of the company.
Recepționează banii.
They receive the money, count them, and later they deposit it in the bank.
Would you say the name of them or cash? 1,500,000 cash. I believe you remember the meetings.
Numele contabilului niciodată nu m-a interesat.
I was never interested in the name of the accountant. Why would I?
The meeting, you didn't know who they are. This is headquarter. You just gave the money and that's it.
Nu este vorba de ședință.
It was not a meeting. It's not that we convene a meeting. We just give some money in cash. So you give it, they are counted, and the receipt is issued. And the accountant signs and stamps the documents. It's very simple. And the receipt mentions this is for this document.
But you said that there were 2 phone calls during 1 year. Whom the phone calls took place?
Da?
Who was the person? Whom you talked?
Cu administratorul?
with the administrator of the company.
Administrator of company. Could you say the name, because we will continue with him now?
Nu știu dacă trebuie un public.
I'm not sure whether I should mention the name publicly. Wouldn't it be an issue?
Alex.
Alex, okay, that's enough. Thank you very much. And if we talk about how you solved the problem and the 2 phone calls, so who exactly solved the problem when it was necessary to solve? It was always him, or sometimes you helped solve the legal problems?
The legal problems were removed by him personally. I did not take part directly or indirectly in this.
But in the meetings where you gave the money, who transmit or who participated in transmission? Always you or your wife? Because as I understand, you bought the commercial space for her. Who transmit the money, the cash?
Eu am fost cel care a transmis.
I was the one who transmitted the money.
And you were alone?
Da.
Yes.
And now we could continue, or do you have questions about the acquisition, or I will finish with conflict of interest when you can ask all the questions about commercial space, yeah? Okay. Let's now move on. According to the information from the integrated case management system, you examined as rapporteur of member of a panel of the Court of Appeal 3 cases where the participation of where participated Paasa de Transport Auto 28. This is the company whom you acquired by cash, a commercial space. In all the 3 cases, the appeals were dismissed by the Court of Appeal via decision of 18th May 2021, 15 June 2021, 7th September 2023. And you signed dissenting opinions in the first 2 cases, it was 2021, stating that the appeal should have been upheld and the claims of Paasa de Transport Auto 28 should have been admitted. Is it correct? Thank you.
Este corect.
It's correct.
And now could you please explain how would you define your relationships with administrator Alex, you said, of a Paasa de Transport Auto 28?
Niciun fel de relație, deci
We had no relationship. We just knew each other. We used to study together during university.
de altfel, cum cunosc o mulțime de colegi de mei care
I have many other colleagues with whom I studied together, whom were colleagues in the dormitory.
Let's clarify. You quite at the same time bought commercial space from the company. It was 2,500,000, and Alex was the administrator of the company. You said that you had phone conversation when there were some kind of problems. So I maybe repeat, what kind of relationships you had?
Dacă mă întrebați sub aspectul
If you're asking whether we are friends or not, we're not friends. We don't meet
evenimentele de familie,
at family events or on other occasions for holidays, hobbies.
are viața lui.
Each has their own life.
Ne-am sunat atunci
We called each other when I was purchasing that property.
asta e ce tot pot spune referitor la
This is
relația
everything I can say in terms of my relationship with him.
But for example, if you met in the street, did you say just hello or you had some kind of conversation with each other?
Dacă l-aș întâlni în stradă,
If I were to meet him on the street, I would greet him just like I greet everyone, every person I ever met.
Did you inform your colleagues in the court about the acquisition of commercial space, about your relationships or not relationships? It depends how it was necessary. Did you inform your colleagues in panel, in Supreme Court, in your court?
am înțeles întrebarea. Nu.
I understood the question. No, I did not discuss with my colleagues.
Nu mi-am spus despre ce
I didn't tell them about this action. This is the truth.
Why not?
De ce nu? Am considerat că
Why not? I considered
o împrejurare care trebuie să
I considered this was not a circumstance that I had to declare because first of all, as a judge,
careva
I had to understand where there were any reasons for me to abstain from judging the case.
de a mă abține,
And since I understood that there was no ground for self-recusal, I thought there was no point in discussing with my colleagues about this transaction I concluded with this company previously.
And you still think that it was right way not to inform your colleagues, not to recuse yourself?
la moment, iată, nu pot să vă spun dacă totuși ar fi fost corect.
Currently, I can't tell you whether it would have been fair to let my colleagues know about these circumstances or not.
La ziua de astăzi, eu sunt sigur că
But
nu erau temeri
as of
de
today,
la examinare.
I am sure there were no grounds for my self-recusal from these cases.
Ori, nu consideram că trebuie să-mi iau abținere,
I
și că
didn't believe that I had to
deci,
ask for self-recusal because this
s-a
transaction
consumat anterior, asta a fost un an
happened
în urmă.
previously. That was more than 1 year
Deci
before.
careva avantaje, beneficii,
So I didn't have any benefits or advantages,
adică vreo obligațiune din partea mea contractuală ca să
or I didn't have any contractual obligations to pay any fees later or anything else.
și am considerat că nu sunt temeri de
And this is why I consider there were no grounds for self-recusal.
Okay, and as I understand, it's last question about this topic. You didn't see any concerns or any thoughts that it can seems against impartiality of judiciary?
Nu?
No.
Thank you. No more question from my side about the acquisition.
Um, Domnul judecător, vreau să mă asigur.
Judge, I would like to understand, I would like to make sure I understand correctly what you are saying. You didn't inform your colleagues or the parties about these facts because you didn't consider that these are circumstances that would require self-recusal. So, coming back to the circumstances, case that we are analyzing. The fact that 1 year before you purchased from this company commercial space in relatively advantageous conditions was not, in your opinion, something that would be in line with the provisions of Article 50, letter A of the of the Civil Procedure Code that would endanger the impartiality of the judges. Is that your position? One remark, you mentioned advantageous price. I wouldn't say that was an advantageous price. That was the real price that I paid. Or you didn't mean this. I meant that this company, according to the information that the Commission has, the company purchased this property at an auction and sold it for the same price. And when a legal entity has two transactions in a row and has no profit from this, the question is, what is the profitability of this? In this case, this transaction can be considered an advantageous transaction because they received no benefits from solving these legal issues. This is why we could say that the transaction brought you some advantages. We're not discussing about a reduced price. I understand the doubts of the Commission. And maybe it's natural for these doubts to occur, but let me put it in another way. First of all, this transaction was concluded, or the pre-sale purchase contract was signed in 2019, not long after they were awarded the winner in the auction. But they weren't after profit, because oftentimes companies alienate some goods without having any profits, just to get rid of some unnecessary things. So the explanation that a for-profit company made this transaction without profit would be an advantage. Judge, all three appeals submitted by this company were rejected. In two of the appeals, you issued dissenting opinions in favor of the company, stating that their proceedings should have been allowed. I apologize, in two cases out of three, because in one of them the appeal was considered inadmissible. Yes, and in these two cases you issued dissenting opinions in favor of this company. I wouldn't say that the dissenting opinion is in favor of a company. The dissenting opinion is issued for a different purpose. Please explain. This is what I considered by analyzing the evidence in the case file, and I thought that this person should have had their claim accepted. This is why I issued this dissenting opinion. This is a rhetorical question. What would be my interest in having a dissenting opinion that doesn't affect the decision of the panel? Of course, this is a rhetorical question.
Mulțumesc.
Thank you. Let's go back to Alex. You mentioned in your answers, and even now you called him, made a colleague from the faculty. That's a broad concept, actually. Could you elaborate more on that? You studied the same year, the same group, or what does it mean exactly? So he was a student 1 year before me. He was I was freshman and he was in second year. So we were not colleagues. We were not in the same group. We studied in different groups. We met in the dormitories, basically. Those who stayed in the residential campus, they knew each other. Briefly, what was the object of the action in those two dissenting opinions? So I have in front of me here the decisions. And for one decision, it was about to cancel an order related to the road network, and the second related to a fine applied by the tax office amounting to 5,000 lei. That's what I recall. So it was about a sanction applied. Sanction from the tax service. If to give more details, I also had such dissenting opinions. I also had such cases with other companies. For example, when we had sanctions applied both to the company and to the driver of transportation means. So, in my opinion, we should separate the liability of the administrator for the violation that is committed by the driver. I cannot recall every detail. It was about some tickets that were not issued by the driver.
Thank you. And the last issue, your involvement in cases leading to ECHR violation. We will talk about 4 cases. First case, we talk about Svernei versus Republic of Moldova. And here we talk about concern limitation of applicant visiting rights. You know what I talk about, the case? This is, yeah, you know, okay, you know the case. Very good.
Da, cunosc.
Yeah. And my simple question is that by what law or legal logic you think that the father's visitations rights here guaranteed by Article 8 of the Convention were properly secured in this case? Just shortly, it's not necessary. Repeat your answers, but very shortly. What was, in your opinion, the legal logic or legal basis?
So in that case, Svernei, in my opinion, the court is less responsible than the authorities in charge of protection of child rights. Because the Court of Appeal's decision was to oblige the guardianship authority or child protection authorities to approve another schedule of visits, another chart of visits. They looked at the best interest of the child. So the first decision the decision of the first instance could not be upheld because, if I remember correctly, the Court of Appeal dismissed the claim on the count related to the obligation to not prevent under any form the contact of the parent with the child. So I remember now that the question was discussed that if the provision would be upheld like that, then it would have come to the situation that the father could come with the idea or having the this reason to visit his child even at 12 o'clock in the night, at midnight, or any other time, because he has the right according to the court decision. So this would not even a barrier, no barrier in his way in that sense. So we try to not have this as a full absolute right and to limit this to have a specific schedule which is approved together with the guardianship authorities.
But my question was about legal basis. Did you use ECHR practice? Did you use some kind of international principles, or did you use only internal law? Do you remember? That is why I ask about not only legal basis, because if you don't remember now, it's okay, but legal logic. As I understand now, for you, just the court was too far from the circumstances, and it should not be responsibility of court. Is it correct, as I understood?
Yes, this should not be responsibility of the court.
Let's take the next case. The next case is Girbu versus Republic of Moldova, and here we talk about different concerns: the failure of national authorities to ensure the enforcement of final judgment and the insufficiency of redress provided by the national remedy used to application to obtain the enforcement and the reparation of damages. We talk about compensation. The first question here is, what was the reason you didn't directly apply the ECHR case law on non-enforcement of judicial decision in reasonable time, in particular with reference to amounts for non-pecuniary damage? So, very simply, what was the reason why you didn't apply directly? Because by that time there were already practice, but you didn't apply. Do you remember the reason why? Why not?
I want to state for sure that the international law was taken into account in this case, because if paying attention to this case, or looking more attentively at this Girbu versus Moldova case, where actually there were several cases merged, unified by the court in just one case. Regarding the case Girbu, the Court of Appeal examined only the non-pecuniary damage part. For the pecuniary damage, he did not challenge the judgment of the first instance. It was about 5,000 euros, the amount decided there. And the first instance court, they decided on this non-pecuniary damage amounted to 20,000 lei, and they challenged it. But the pecuniary part, it was not challenged. So now, if looking in the decision of ECHR, we can see that they were the pecuniary damage was accepted for his side because he had several actions sent to court.
Okay, in this case, as I know, but you can agree or disagree, there were also recommendation from Supreme Court of Justice. And were you aware of his recommendation of a Supreme Court of Justice? And of course, the second question is why you didn't follow the recommendations.
Regarding the non-pecuniary damage, I cannot recall now.
If you don't remember, it's absolutely okay.
Nu mi-aduc aminte.
Okay. The third case is
Al treilea caz
versus Republic of Moldova, and here we talk about domestic violence and victims' rights. You know the case?
Da.
yes.
And here I would like to ask that by what law, in your opinion, the victim arguments, for instance, the living of perpetrator in the same house across the wall. So how you think that it wasn't the psychological abuse or how you explain here your decision?
Decizia asta, deci a curții,
This decision of the Court of Appeal.
o să încep cu cei care au fost
Okay, in that case, let me start, but it was issued by a panel of judges that I was part of, and two other well-known judges having experience that was broader than mine.
Deci eu eram
I was a beginner in the Court of Appeal,
dar nu asta e problema.
but that is not the main problem. From what I remember, and
Cauze.
yeah,
Este despre cei care
referring to the materials of the case, we actually dismissed the extension of protection order for the victim of domestic violence after
după aplicarea, deci, anterior, pe un termen de 90 de zile.
this previously was applied for a period of 90 days.
Noi, sau completul de judecată,
So the panel
a apreciat
examining that issue, they analyzed the evidence presented in the first instance court. They reviewed them
deci, spunem așa, deci
because in the second appeal,
persoanele n-au depus careva,
the people did not come with those persons did not come with additional evidence.
atestau la momentul și
The materials that
nu s-a confirmat.
existed at the moment of the examination did not confirm the violence that the person claimed to exist.
You know, my very last question about this case is, we know that in this case, the Court of Appeal didn't give any answer to the victim's argument regarding the disconnection from the drinking water on 13th of September 2016, and of a part of a house where the victim lives with her children. So just my very last question, did you see the incident as a form of psychological abuse or no?
Dacă este vorba de o deconectare de apă,
Talking now about this disconnection of utilities, of water supply, which allegedly was done by that person, yes, this is a form of violence.
dar la cazul respectiv,
But in that case examined by us, I once again
nu au fost
say that evidence were not presented to confirm the statements of the victim. The victim could not prove that those facts.
să zicem așa, fără
The statements had no evidence to support.
oră. Deci, de câte mi-aduc aminte, deci faptul de conectări
The disconnection of water supply and any other actions were examined in a criminal case in that time.
Thank you. Thank you for the long hearing and no question from my side.
Judge Dașchevici, our panel ran out of questions that we had. Would you like to come with a final statement now? Just a brief one. I rely on the fact that the Commission will review my case in an objective way. I really rely on that. I really hope that. We are at the end of this hearing. Mr. Dașchevici, thank you very much for your participation in the hearing, for the answers and information you provided to the request of information during the evaluation. After the hearing, the panel will approve an evaluation report to include the conclusions regarding the compliance of the subject with the ethical and financial integrity criteria. The Commission will strive to draft and approve the report as soon as possible. Thank you very much. I declare this hearing closed.